Sharing recognition as Ambassador GERARD NSENGIYUMVA, the Black Chair, Part B of UN Human Rights Mechanisms, Complaint Procedures, Opportunities for UNHCR and other human rights organizations to address individual human rights violations. While the 1951 Convention and the Statelessness Conventions do not have formal mechanisms for individuals to file complaints, most of the UN treaty bodies have provisions in place which allow, under certain circumstances, for complaints procedures to be activated. These procedures may relate to individual complaints, complaints by affected individuals or groups, or complaints by other state parties, for committees to have the authorities to conduct individual complaints procedures, and issues. The state party must have recognized the complaint or the competence of the committee monitoring the relevant treaty. To do so, this may require the state to have ratified an optional protocol, as is the case for the Committee on the Rights of the Child, for example, or to have made a declaration in relation in a specific article of the Convention ratified. For example, Article 22 of the Convention against Torture. Individual complaint procedures are mechanisms for bringing cases of alleged human rights violations to the attention of the United Nations with the objective to prevent such violations or to seek redress in case they have already occurred. Where an individual complaint has been brought, the UN human rights bodies may issue immediate interventions requesting that the state adopt their measures to prevent irreparable harm pending a final decision on the complaint. States that have accepted the competence committees to receive such complaints also implicitly committed to respect their requests for interim measures and implementing their final decisions. So about interim measures, interim measures may offer protection to persons who claim a violation of their rights under a specific convention before the responsible committee issues a decision on the admissibility of the merits of the case, and without prejudice to the committee's final decision. With some exceptions, in the vast majority of cases that have respected committee requests for interim measures. To go further, there are very good examples on that. Then the UN Human Rights Council that is charter-based mechanisms. The Human Rights Council is the principal intergovernmental body within the UN system responsible for strengthening the promotion and protection of human rights violations and making recommendations on them. The Council was established on March 15, 2006 by the General Assembly Resolution 60/251 and is made up of 47 UN member states which are elected by the General Assembly, General Assembly. The Human Rights Council meets at least 10 weeks per year at the UN office in Geneva, Switzerland, in regular sessions usually taking place in March, June, and September. The Council is also convening urgent meeting on short notice to respond to emerging human rights crisis. The Council can adopt non-binding resolutions with or without a recorded vote. To adopt a draft text by vote, it must enjoy the support of the Council, and only Council members are able to vote. To date, the Council has adopted more than 600 texts to address a range of thematic and country-specific human rights issues in addition to the member states of the Council and the non-member states participating as observers, intergovernmental organizations, national human rights institutions, and accredited non-governmental organizations in consultative status may also participate actively in Council sessions. The Council also has established and oversees a number of subsidiary human rights mechanisms, including subsidiary mechanisms like the complaint procedure, subsidiary expert mechanisms, forums and working groups, the universal periodic review, specific procedures, independent investigations, those are commissions of inquiries and fact-finding missions. During the Council sessions, UN agencies, national human rights institutions, and accredited non-government organizations have observer status and can participate in the public discussions and debates on myriad of human rights issues discussed by the Council. The UNHCR can also engage with the member states to provide input to draft resolutions and other texts which are adopted by the Council. Observers may also host or participate in public side events to the Council, which can be a useful means of highlighting emerging human rights issues or urgent human rights concerns in particular context. In general, the Council's complaint procedure is a confidential process aimed at addressing consistent patterns of gross and reliable attested human rights violations occurring in any part of the world. The Council has also established a number of subsidiary expert mechanisms, forums, open-ended working groups, which can contribute thematic expertise, provide platforms for dialogue and operation, elaborate new draft legal instruments, and or make recommendations on the implementation of existing instruments. In here, I will also talk about the functioning of the universal periodic review, the specific procedures, and the independent investigations, including commissions of inquiries and fact-finding missions, which are three types of subsidiary mechanisms of the Human Rights Council. The Human Rights Council's Universal Periodic Review, or UPR. The UPR is a unique state-driven process which involves the regular public review of the human rights records of all UN member states. During UPR working groups meetings held 3 times per year, UN member states spell out positive achievements, express concerns, and recommend reports, recommendations to the states under review. Each year, 42 states are reviewed, and a cycle is complete once all states have been reviewed. The process is currently in its 3rd cycle. That was by the time I learned this course, the process was at the 3rd cycle. The reviews assess the extent to which states respect their human rights obligations set out in 1. the UN Charter, 2. the Universal Declarations of Human Rights, 3. human rights instruments to which a state is party, human rights treaties ratified that by the states concerned. Then 4. voluntary pledges and commitments made by the state, example, national human rights and regional policies. 5. applicable international human rights humanitarian law. States receive receive an average of 180 recommendations. Each reviewed states are then expected to indicate which recommendations they support on the report on measures and steps taken to implement them. The Universal Periodic Review also provides a space for states to request technical assistance from other states to enhance their capacity to deal effectively with the challenges and for them to share best practices. The ultimate aim of this process is to improve concretely the human rights situation in all countries with the significant consequences for people around the globe and address human rights violations whenever they occur. The following talk actually typically explains that typically the review process for UN member states during one cycle of Universal Periodic Review. There is what we call segment in sequence actually, which is preparation of a pre-session documents, stages of review process. We are going to see the stages of the review process of the UPR. One, preparation of pre-session documents. Three main public documents are prepared and form the basis for review. One document is the state report, information provided by the state under review on measures taken to improve the human rights situation in the country and outstanding challenges as relevant and appropriate based on the operational context and the relationship with the government. UNHCR and other stakeholders can support the government counterparts preparing the state report to highlight positive development and outstanding challenges in relation to protecting the human rights of displaced and stateless people. The document number 2 is the compilation of UN information. Information contained in the reports of UN special procedures and human rights treaty bodies and other UN entities. UN agencies may contribute standalone public reports for their documents, highlighting positive developments and putting forward recommendations which could be made the state under review to improve the human rights situation for displaced and stateless people. Typically, UN agencies also have the opportunity to contribute information to a multi-agency or UN country team report. Document number 3 is the summary of stakeholders' information. Information from other stakeholders, including national human rights institutions and non-governmental organizations. Then let's go to the main document number 2, UPR Working Group Review and Report. The UPR Working Review involves a 3.5-hour discussion between states under review and other UN member states. Any UN member state can pose questions, comments, and or make recommendations to the state under review following the review by the working group. The working group report is prepared. It consists of questions, comments, and recommendations made by the state to the country under review, as well as the responses by the reviewed state. The addendum is the main document number 3, which is the addendum. Following the review and prior to the Human Rights Council adopting of the report, the reviewed state has the opportunity to submit an addendum to the working group report. In an addendum, the state may give final indications as to whether it supports or not recommendations received in the working group report. But usually, if such indications were not made before the working group report was completed, and may provide further responses or information in relation to the recommendations received. Human Rights Council adoption and report, that is the main document number 4. The working group is formally adopted at the plenary sessions of the Human Rights Council. During the session, the state under review can reply to questions and issues that were not sufficiently addressed during the working group and by states during the review. Time is also allocated to members and observer states who may wish to express their opinion on the outcome of the review, and for national human rights institutions, non-governmental institutions, organizations, and other stakeholders, including UN agencies, to make general comments. The main document number 5 is the national process of follow-up and implementation. The state has the principal responsibility to implement the recommendations contained in the final outcome. During subsequent reviews, the state is expected to provide information on what they have been doing to implement the recommendations made during the prior review, as well as on any developments in the field of the human rights. States and other stakeholders may also submit mid-term reports on their progress between reviews. The international community, including UN entities, plays an important role in assisting the states to implement the recommendations and the conclusions, including through the provision of technical expertise and the capacity building. There is a self-reflection question one can ask, which is when was the last time your country of operation was reviewed by the Universal Periodic Review process? Were any recommendations made in the report of the working group of relevance to the protection concerns of displaced and stateless people? What kind of universal periodic review recommendations could be useful in the future to support UNHCR advocacy for the improvement of the protection environment for displaced and stateless people? Then we need also to understand the special procedures of the Human Rights Council. The special procedures of the Human Rights Council are independent human rights experts with the mandate to report and advise on human rights from a thematic or country-specific perspective. As of March 2018, there were 44 thematic mandates, 12 country mandates. Common features of special procedures mandate holders. Each of the special procedures mandates are established by resolutions of the Human Rights Council, and each of the individual mandate holders are appointed by the Human Rights Council. That said, all of the 56 mandates share some common features, which are: special procedures are either an individual called special rapporteur or independent expert, or simply it's a working group composed of 5 members, 1 from each of the 5 UN regional groupings. The special rapporteur, independent experts, and members of the working groups appointed by the Human Rights Council serve in their personal capacities. They are not UN staff members and they do not receive financial remuneration. They undertake to uphold independence, efficiency, competency, and integrity through probity, impartiality, honesty, and good faith. A mandate holder's tenure is limited to a maximum of 6 years. Special procedures can undertake country visits, act on individual cases of alleged violations and concerns of a broader structured nature by sending communications to the states, conduct thematic studies, and convene expert consultations contributing to the development of international human rights standards, engage in the advocacy and raise public awareness, provide advice for technical cooperation. Special procedures also provide annual thematic reports along with the final reports from any country. Visits undertake to the Human Rights Council. A majority of the mandates also submit annual thematic reports to the General Assembly. There is an executive list of special procedures which may have particular relevance to displaced and stateless people. For instance, special rapporteur on the human rights of internally displaced persons, special rapporteur on the human rights of IDPs, internally displaced persons, guiding principles on internal displacement. It may be found on the UNHCR website, which is www.unhcr.org. Special rapporteur on torture and other cruel in human degrading treatment or punishment, working group on arbitrary detention, special rapporteur on extrajudicial summary or arbitrary execution, special rapporteur on violence against women or its causes and consequences, special rapporteur on the human rights of migrants, special rapporteur on minority issues, special rapporteur on trafficking in persons, special rapporteur on the situations of human rights defenders. Then we will have to know that there are also independent investigations or commissions of inquiry and fact-finding missions. The Human Rights Council, as well as the Security Council, General Assembly, Secretary General or High Commissioner for Human Rights can establish commissions of inquiry, fact-finding missions, and other investigations which respond to certain or protracted serious violations of international human rights and humanitarian law. They produce hard-hitting evidence on war crimes and crimes against humanity, feeding into formal justice processes to hold the violators accountable. Where relevant and strategic, UNHCR can engage with these independent investigations to highlight and use the outcomes of these mechanisms to enhance the outcomes of those mechanisms. To 32 such commissions and missions had been created, and 8 were active actually as of the middle of 2021. 32 such commissions and missions had been created and only 8 were active. And those 8 were actually, we have Myanmar, 1, 2, Yemen, 3, Democratic Republic of Congo, 4, Syria, 5, Libya, 6, Yemen, 7, South Sudan, and 8, Burundi. Then we have to understand regional human rights systems, and regional human rights systems is what I'm going to discuss in the next part, which is part 3. Thank you very much for watching.